All right, so we are here today with Mr. Rahul Soni. He's a distinguished partner at Fragomen, focused primarily on high net worth and ultra high net worth clients across the United States, Europe, the Middle East, and Africa. Rahul is instrumental in managing high profile corporate clients in sectors such as financial services, technology, and luxury brands. As it relates to our discussion today, though, Rahul is known for his knowledge of EB-5 immigration and residency by investment, helping clients secure permanent residency in the U.S. and other jurisdictions. And I'm certainly glad to have you here today. We're going to discuss some of the historical and more recent issues with H-1B and F-1 visas, and maybe what sort of role EB-5 can play as an alternative in the space and how the visas can all sort of interact together. So, Mr. Soni, if you'd like to introduce yourself briefly here.
Yeah, exactly. Thanks for the introduction. As you said, I'm a partner at Fragomen. I manage our corporate clients and private client practice in the US. Have a particular focus on high net worth individuals and our high net worth individual client portfolio, and specialize a lot in EB-5 applications as well.
Fantastic. Well, we'll certainly have a lot of overlap in the discussion today then, which is great. So I'd love to just jump right in with some basic questions about, like I mentioned, how the visas can differ and how they can interact together. So in your experience, can EB-5 serve as a legal fallback or sort of backup plan while visa petitioners remain on F-1 or H-1B?
Yeah, absolutely. One of the great benefits that we find is that EB-5 can really run in the background while individuals are on an underlying non-immigrant visa status like H-1B or F-1, where they can maintain their H-1B or F-1 status and apply for EB-5 in the background. So in essence, it not only serves as a backup, but sort of a transition to their next phase, which is their step up into permanent residency. So we have at Fragomen a large volume of clients who are already in the United States on non-immigrant visas like an H-1B and are utilizing a green card mechanism like EB-5 to sort of transition themselves to that next step.
So it can be thought of a little bit less as a fallback or backup plan and more sort of as the logical next step in the transition, as you're saying, towards permanent residence. Is that correct?
Exactly. And a lot of our clients, especially those who are seeking H-1Bs, let's say F-1 students who are getting close to graduating and looking to transition to an H-1B in a professional occupation, they're going into this world of extreme competition. The H-1B visa process runs on a lottery basis, as a lot of us know. And so it's highly competitive, meaning that even the most well-qualified individuals often don't make it through the initial phase, which is the lottery. For that reason, among others, they utilize EB-5 to try and secure permanent residency in advance of them even having to need to use an H-1B.
Right, right. And just on that note, I'm curious your thoughts about that lottery system. Is it something that you find, as an immigration attorney, something that you find frustrating or something that clients, voice their frustration about? What are your thoughts on it, that system?
It is frustrating in some ways because it's capped. It's capped at 85,000 H-1B visas per year. And there are almost always historically more visas, more applicants than there are visas available, meaning that there are so many well-talented individuals that don't make it through. There are, of course, other non-immigrant visa solutions. And so at the firm, we do a lot of sort of strategy and mitigation to try and find other solutions for individuals. But it's often the case that individuals who are well qualified don't make it through the lottery. So it is frustrating. But the sort of silver lining is that there are other avenues. Those who are fortunate enough to be able to utilize EB-5 can sort of move to that instead and try and avoid this whole situation altogether. But yeah, absolutely frustrating. I mean, even I went through it myself as an immigrant in the US, and just to go through that sort of level of competition where you know that you're well qualified for a job it's quite tough.
Sure. Yeah, I think there has to be certainly a lot of frustration in the sort of misalignment between being well qualified and, having the sort of attributes and assets to bring positives to the United States, whether it's, the economy or through working or whatever your purpose is, and not be seen that way. I'm sure it must be a very frustrating thing that you hear about quite a bit. That being said, what are some of the benefits, if any, that a petitioner might risk losing by switching to EB-5 from H-1B or F-1? Is there anything at risk?
From an immigration standpoint, not really, because they're taking a jump up from a more restrictive immigration benefit like an F-1 visa or an F-2 visa, which is strictly tied to the program of study, so their degree program, for example, or in the context of an H-1B, the visa is strictly tied to the employer and that position that they're performing. Every time they need to renew the visa, they have to go through the process again. If they want to switch employer, they have to go through the process again. If they want to transition to a different visa category, same thing, starting a process over again, moving up the sort of ladder, if you will, to permanent residency affords them that level of freedom. So from my perspective, there's not really any benefits immigration wise the applicant risks losing. From a taxation standpoint, and this comes up a lot in the context of EB-5 with our high net worth and ultra high net worth clients, is there are taxation benefits, or rather issues of exposure, when an individual attains that level of permanent residency that they may want to consider as sort of specifically as it pertains to their worldwide assets and income. So if we were thinking about benefits they may risk losing, it's usually a non-immigration, maybe taxation issue rather than an immigration one. But from our perspective as immigration lawyers, it's really sort of a level of freedom that they're getting to by receiving an EB-5 green card.
Sure. Yeah, and you bring up a good point, which is I think the variations between the advantages and disadvantages and benefits and risks of the investment side as opposed to the immigration side. They vary, as you know better than anyone, I'm sure, that they vary greatly between the two very separate issues, obviously. There's an Economic Times article published not too long ago that emphasized how the F-1 and H-1B visas ultimately were never designed to provide permanence, I think is the wording that they used. Vulnerable to revocation without due process. We've seen some of the horror stories about students at top universities running into these sorts of issues. In your experience, have you seen clients unexpectedly lose status? And if so, what are some of the immediate steps they can take to try and stay compliant?
Yeah, I definitely think there is some truth to that. Non-immigrant visas like F-1 and H-1B are inherently temporary in nature. That's sort of the nature of most non-immigrant visas. F-1 student visas, they're designed for being valid for the duration of study. Literally, when F-1 student gets admitted into the United States, they're stamped with something called D/S, which is duration of status. It's tied to the status of their program of study. With H-1Bs, they're temporary in nature. They max out at 6 years. There are some limited ways to extend beyond the 6-year maximum period if an employer has proceeded with a green card through the US Department of Labor, for example, and made certain headway. An individual who's usually typically stuck in visa backlogs can extend beyond the 6-year maximum, but they're still sort of inherently temporary in nature. So I think that Economic Times article does have some truth to it. We do see clients lose status from time to time. That in the context of F-1 visas, especially in light of the current administration, it's all over the news about F-1 visa revocations. We're really sort of advising our F-1 F-1 student clients to just sort of be really by the book when it comes to abiding by immigration law, not engaging in sort of unauthorized employment, that kind of thing, to avoid any issues with F-1 visas either being issued, avoiding revocation, not having issues at the border. And then with H-1Bs, every time that an individual needs to renew them, they have to go through the application process again, apply for the H-1B through the US Citizenship and Immigration Services, essentially have an officer re-review the case from scratch as if it's a new application. So we do see issues come up from time to time where there are requests for evidence, potential denials, that kind of thing. we at the firm try to ensure that we're preparing extremely ironclad petitions for our corporate clients who are applying for H-1Bs for their employees for that reason, to avoid any of those issues. But of course, we always have conversations with both the employer and individuals who are applying for the benefit to ensure they understand the sort of nature of the beast that they're going into and try and avoid any issues, and also prepare them for what may happen.
Sure, sure. So talking about what may happen, you mentioned RFEs or denials, that sort of thing. I want you to compare historically and then under the current administration, just because I'm curious, what types of RFEs or denials have you most commonly seen with H-1B or F-1 extensions? And like I said, when you compare it historically to the current administration, and my follow-up question was, how do you prepare clients for these risks? You've already touched a little bit on that preparation, but again, when you compare historically to the current administration, let's say, what are those types of RFEs and denials that you're most commonly seeing?
So with F1 specifically, they're usually issues on the consular side. So more often than not, an individual is going to apply for an F1 visa at a US embassy or consular post rather than while they remain in the US. You can, but the most common way to do it is at the US embassy or consular post. There are certain, there's certainly a spike in issues at US embassies and consular posts, which are managed by the US Department of State at the moment under the current administration. We're seeing more visa denials than before. Things like very minor arrests are being flagged up and potentially triggering denials. We really have to do a very sort of in-depth review with any of our clients who are going in for an interview to make sure that we're aware of all of the sort of background of the client, including any criminal issues, because they're very likely to be raised. There are sometimes various issues of misrepresentation that can be raised by US embassies and consular offices. So it's really just making sure that the client is very well prepared. And if there is sort of any additional explanation needed, that the client has that to explain. But yes, I think there's certainly a spike in things being raised. When it comes to H-1Bs, RFE trends are sort of increasing under the current administration. It's the most common, I would say, are things like questioning whether a position is truly a professional occupation. So if it actually meets the true definition of what an officer is looking for in the H-1B context, or questioning the individual's qualifications to perform the position, perhaps reviewing the nexus between the individual's qualifications and the job. But our legal teams in the US are sort of very well equipped to prepare very detailed responses to these RFEs. So, the firm's denial rate is still very low, but we are seeing a sort of spike in issues and questions raised by USCIS.
Sure. And I would imagine that sort of preparation, or that risk mitigation, I suppose you could call it, in response to, preparing for RFEs or that sort of thing would be a pretty serious or pretty major part of the work that you do. Is that correct?
Yeah, that's correct. And it's a lot of counsel with our corporate clients to make sure that, we're reviewing in depth with them the kinds of individuals they're putting forward for H-1B applications, for example, to make sure that we think there's a very good shot at getting the cases approved, and flagging any issues, whether it's a wage issue or a job description issue or anything that we think may trigger an RFE. And then equally on the sort of side of the applicant, having a sort of very deep review of their background to make sure that we're looking at what their previous employment is, their positions make sense, they haven't engaged in unauthorized employment, there are no criminal issues, that kind of thing.
So it seems very, very important to tick all the boxes properly in that sense. Then I want to switch gears a little bit and talk about family, spouses and children. One of the major benefits of the EB-5 program is that spouses and children can receive green cards and work freely. So I just wanted to pick your brain. How does that family level security compare to, for example, what an H-4 dependent would get under H-1B?
Yeah, it's a good question. So with H-4 dependents, firstly, not all H-4 dependents will receive work authorization. It's really reserved for a select group of H-4 dependents who typically are stuck in visa backlog, so retrogression, and they can't advance to the final stage of their green card application. They're typically eligible for work authorization. That is strictly tied to the principal's H-1B work authorization. In the context of green cards, it's complete freedom in terms of employment authorization, right? There's no restrictions. It doesn't expire. Even if the physical green card expires, the work authorization doesn't, as long as the green card's renewed on time. So it's essentially complete freedom. So in my opinion, it's pretty incomparable. It's a huge level up for an individual to receive a green card. In fact, our clients, especially our EB-5 clients, they often tell us how relieved from a sort of mental and emotional perspective they feel that they have a green card in hand, that they don't have to sort of worry about the employer of the H-1B terminating the employment and everyone losing status, for example. So it's typically a massive relief for our clients.
Good, good. That's good to hear. Well, I want to try a little bit of an interesting thought experiment here. If you look ahead 5 years and, taking a look at certain policy levers, let's, visa number relief, wage level reform, further tightening of third party H-1B work, of those things or other things, what do you predict is most going to intensify demand for EB-5 among recent graduates, if you think that demand will intensify at all?
Yeah, I mean, we're kind of seeing it now in the current administration. And I think, at least for the foreseeable future, I think that trend will continue where it's not just what may happen in the context of changes to H-1Bs or other non-immigrant visas programs, but it's really what's happening now as well, which is the scrutiny of visas like H-1Bs, L-1s, even consular-based applications like TNs and E3s. They're receiving so much more scrutiny than before that individuals are turning to EB-5 to secure green cards quickly and efficiently for their families. EB-5 is it's running in a really beautiful way at the moment. The applications are getting approved at lightning speed. The government introduced the EB-5 Reform and Integrity Act a few years ago and carved out these specific subcategories of projects that allow for expedited processing. And our clients are really taking advantage of those and applying and getting green cards issued sometimes in under a year. So it's an amazing environment for people to get green cards. And I think looking ahead that trend is going to continue as long as EB-5 is around, because it's just an extremely successful way for individuals to get green cards. We've never had any issues with our clients not being successful through this process. So I think it's perfectly positioned to be that sort of saving grace for individuals as we see more issues come into play with, various non-immigrant visa categories, that people will turn to this to sort of free themselves and sort of create a harmonious environment for their families and just move to green cards without having to deal with the stress of non-immigrant visas.
Excellent, excellent. Well, I just have one last question for you. You mentioned RIA there, of course, the Reform and Integrity Act. And with that came the ability to concurrently file. So for foreign nationals living in the United States, obviously, avoiding the consular process, their entire process can be much more expedited. The ability to adjust their status has been so huge for the EB-5 program post RIA. What are your thoughts, having obviously worked through that period and worked through the Reform and Integrity Act being introduced? How has that ability to concurrently file impacted EB-5 and impacted your clients specifically?
It's impacted our clients massively, because a large percentage of our EB-5 client portfolio is our clients who are in the US and actively on another visa. it's often F-1 students or individuals on H-1Bs. So very much the context of what we've spoken about today. And they're availing concurrent filing. There are currently no backlogs for anybody if you're clever about doing the application and you pick the correct regional center and project, which of course we both know well. And that really provides these individuals with the ability to file their initial I-526E petition, their adjustment of status for their families. They get employment authorization documents issued really quickly, often in about 3 months. Their advanced parole is usually issued in about 8 or 10 months at the moment. And then the green card follows pretty soon after. So it's just been this sort of life-changing environment for our clients where they can just move through the process at lightning speed. Something that used to take years now takes sometimes a year. And so it's been fantastic for them.
Absolutely. And, I think that's a point that, regional centers, especially us here at Houston EB-5, are trying to emphasize, is the ability to concurrently file like that. And even outside of just the concurrent filing, the speed at which these approvals are going through in the EB-5 space is really, really a positive thing for foreign nationals who are targeting immigration via investment, of course. Well, I want to thank you so much for your time. I appreciate you being here. Do you have any final thoughts on the issue that you'd like to share?
Well, really, just in summary, I mean, of course, these non-immigrant visa programs are all very much active, and we routinely help our clients through them. And the issues that we ultimately face with our clients, especially when it comes to denials, are extremely low. But there is certainly some sort of detailed work to be done in various visa categories to make sure that we're assisting our corporate and individual clients really effectively, especially through maybe a tougher administration. But in contrast, it's really been sort of a nice light at the end of the tunnel, so to speak, to have EB-5 still be so efficient, not just from a timing perspective, but from an approvability perspective as well. Seeing these cases get approved, almost very rarely seeing RFEs. And so it's an excellent EB-5 environment.
Excellent. Well, it's great to hear that from someone like you who has so much experience in the space and has dealt with so many different visa types. So again, I really appreciate your time today, and thank you very much.
Likewise. Thanks for having me.